Hi, hello everyone. Welcome back to my channel. We are back with the glossary of legal terms. The first phrase today is abstract of title. An abstract of title is a condensed history of all the legal transactions, transfers, encumbrances, and claims relating to a particular parcel of land. It includes deeds, wills, mortgages, liens, and judgments that establish ownership and any limitations on it. The abstract is prepared by professionals to verify whether a seller has a valid title to transfer. It helps prospective buyers, lenders, or lawyers ensure that no hidden legal problems exist. Its scope is primarily in real estate, property law, and conveyancing. The next phrase is abuse of process. Abuse of process refers to the misuse of legal procedures for purposes other than what they were intended. It occurs when a party uses the court system not to achieve justice, but to harass, intimidate, or coerce another person. This can include tactics like filing frivolous lawsuits, issuing unnecessary subpoenas, or prolonging litigation. Courts recognize abuse of process as a civil wrong which can lead to damages or sanctions against the wrongdoer. Its scope covers civil and criminal litigation where judicial procedures are distorted. The next term is acceptance. Acceptance is the voluntary agreement to the terms of an offer, creating a legally binding contract between parties. In a contract law, acceptance must be communicated clearly and must correspond to the offer's conditions without changes. It may be expressed through written or spoken words or implied through contact. Acceptance is crucial because it transforms an offer into a contract enforceable by law. Its scope spans commercial transactions, employment agreements, and everyday contractual dealings. The next term is avoirdupois. Avoirdupois is a system of weights used primarily in English-speaking countries for measuring everyday commodities except precious metals and drugs. It is based on a pound of 16 ounces, where each ounce equals 437.5 grains, making a pound equal to 7,000 grains. The system developed from medieval commercial practices and became widely standardized in England during the 14th century. Today, it is mainly used in the United States and to a lesser extent in the United Kingdom. Its scope lies in trade, commerce, and a daily measurement of goods like food, raw materials, and industrial products. The next term is accrual. Accrual refers to the gradual accumulation of rights, obligations, or income over time rather than at once. In accounting, it means recognizing revenues and expenses when they are earned or incurred, regardless of when cash changes hands. In law, accrual may also mean the point at which a cause of action or right arises. For example, interest on a debt accrues day by day even if payment is later. Its scope lies in accounting, taxation, business law, and a contract enforcement. The next phrase is acceptance of service. Acceptance of service occurs when a person formally acknowledges receipt of legal documents such as summons, complaints, or court orders. Instead of requiring a process server, the receiving party voluntarily accepts the papers. This acknowledgement may be written and signed to confirm that service is valid. Acceptance of service speeds up legal proceedings and avoids disputes about a proper notice. Its scope is in civil procedure, litigation, and administrative law. The next term is action. An action is a formal legal proceeding initiated in a court of law to enforce or defend a right. It is broader than a lawsuit as it encompasses civil and criminal cases, petitions, and claims. Actions generally follow prescribed procedures including filing pleadings, presenting evidence, and receiving judgment. They serve as the vehicle through which justice is administered and legal remedies are sought. Its scope is universal in law, covering every branch from civil disputes to constitutional claims. The next term is acquiescence. Acquiescence means passive acceptance or silent consent by failing to object to a situation or act. In law, it can imply that a person's inaction or silence indicates agreement, especially when they have the opportunity and a duty to speak out. For example, if someone continuously allows another to use their land without protest, they may lose the right to challenge it later. It differs from consent because it arises from inaction rather than active approval. Its scope is found in contract law, property disputes, and equitable doctrines. The next phrase is accord and satisfaction. Accord and satisfaction is a legal method of settling a dispute or unliquidated claim by agreement between the parties. Accord is the agreement where one party accepts less or different consideration, and a satisfaction is the execution of that agreement. Once completed, the original obligation is discharged. For instance, if a debtor pays part of a debt and the creditor agrees to accept it as full settlement, the claim is extinguished. Its scope lies in contract law, debt settlements, and a dispute resolution. The next term is accountability. Accountability is the obligation to answer for one's actions, decisions, and duties, especially in positions of trust or authority. It implies responsibility to stakeholders, superiors, or the public for the outcomes of conduct. In law and governance, accountability ensures transparency, checks abuse of power, and enforces liability. It may extend to political leaders, corporate managers, fiduciaries, and even individuals in an everyday context. Its scope covers ethics, law, management, and governance. The next term is accounting. Accounting is the systematic recording, reporting, and analysis of financial transactions of an individual, organization, or government. It ensures accuracy, compliance with the legal standards, and a clarity in financial decision making. Beyond a bookkeeping, accounting interprets data to assess performance, risks, and sustainability. In a law, accounting may also refer to a court-ordered disclosure of financial records. Its scope extends across business, taxation, auditing, and litigation. The next term is accusation. An accusation is a formal or informal statement that someone has committed a crime, wrong, or misconduct. It can arise from individuals, institutions, or state authorities and may lead to investigation or prosecution. In criminal law, an accusation usually precedes a charge or indictment. False accusations can be damaging, while substantiated ones trigger legal accountability. Its scope lies in criminal justice, workplace regulation, and social relations. The next term is acknowledgement. Acknowledgement is a formal declaration by a person, often before an authorized officer, that a document or act is genuine and voluntary. In property transactions, it confirms that a deed or agreement has been signed willingly. In general terms, acknowledgement can also mean recognition of receipt, responsibility, or truth. It provides legal validity to documents and prevents disputes about authenticity. Its scope is in notarial acts, property transfers, legal filings, and professional dealings. The next term is acquittal. Acquittal is the formal legal judgment that a person accused of a crime is not guilty of the charges. It occurs after a trial when the court finds that the prosecution has failed to prove the case beyond a reasonable doubt. Acquittal frees the accused from criminal liability for that particular offense. It does not necessarily mean innocence, but rather insufficient proof of conviction. Its scope is within criminal law and judicial procedures. The next term is actionable. Actionable refers to a situation, conduct, or statement that gives us sufficient grounds to bring a lawsuit. For example, defamation, breach of contract, or negligence may be actionable if they cause harm. Not all wrongs are actionable, only those recognized by law as giving rise to remedies. It signifies the threshold for turning a grievance into a legal claim. Its scope lies in torts, contracts, and a constitutional rights enforcement. The next phrase is actionable per se. Actionable per se means that a wrongful act is inherently actionable without the need to prove actual damage. In such cases, the law presumes harm from the very nature of the act. Classic examples include defamation, trespass, and a false imprisonment. The injured party can directly file a case without showing financial or physical loss. Its scope is important in tort law, where certain rights are protected absolutely. The next phrase is actual notice. Actual notice occurs when a person has direct knowledge of a fact, event, or legal proceeding. It can be through oral communication, written notice, or first-hand observation. In law, actual notice binds a person because they are genuinely aware of the matter. It is different from constructive notice, where knowledge is legally imputed even without a direct awareness. Its scope lies in property transfers, litigation, and administrative law. The next phrase is actual possession. Actual possession refers to physical control or occupancy of property by a person. For example, living in a house or holding goods in hand constitutes actual possession. It differs from constructive possession, where a person has legal rights but not a physical control. Actual possession strengthens ownership claims and is relevant in disputes over property or criminal cases involving illegal items. Its scope lies in property law, landlord-tenant relations, and a criminal law. The next term is actuary. An actuary is a professional who applies mathematics, statistics, and a financial theory to assess risk and uncertainty. They are essential in insurance, pension planning, and investment management. Actuaries calculate premiums, forecast future liabilities, and design risk management strategies. Their work ensures financial stability for organizations and individuals facing uncertain events. Its scope extends to finance, insurance, economics, and policy planning. The next term is adaptation. Adaptation means modifying something to suit a new use, environment, or context. In a copyright law, adaptation refers to creating a new version of a work, such as turning a novel into a film or translating it. In biology and everyday life, adaptation signifies adjustment for survival or success. Legal adaptation ensures respect for intellectual property rights and requires permission from the original creator. Its scope spans literature, media, science, and intellectual property law. The next term is addendum. An addendum is an additional document or section added to a main contract, agreement, or publication. It modifies, clarifies, or supplements the original terms without rewriting the entire text. Addenda are often used in business contracts, leases, and official reports. They must be legally valid, signed, and consistent with the original agreement. Its scope lies in contract law, publishing, and administrative practices. The next term is adhesion. An adhesion contract is a standardized agreement drafted by one party, usually stronger, and offered to weaker party on a take-it-or-leave-it basis. The weaker party has little or no opportunity to negotiate terms. Examples include insurance policies, online service agreements, or consumer contracts. While legally binding, courts may strike down unfair or oppressive terms. Its scope lies in consumer protection, contract law, and commercial regulations.